So friends, welcome to Mineral Project Information. I am Soumitra here, and today we are going to talk something different. So usually we talk about various issues in regards to package drinking water problems and all that. So today we have an expert with us. She is Ms. Shalaka from IP Adventure. Okay. So why she is there, I would just like to introduce you. First of all, there was a news in the on the media. I think which was a paper. I think Shalaka, one of the paper.
It was in many newspapers
Many
like
newspapers.
Indian Express and Deccan Herald and
Okay.
almost in every newspaper.
Okay, so the news was really
Times and all.
encouraging. The news was very encouraging that there is a company from Hyderabad who has won the battle against who? A giant, that is Pepsi. Okay, this was the news. And what was it? You must have seen the advertisement. Dar kya ke jeet hai. So that is a slogan of which company? It's Mountain Dew. Okay, so there was a news that this small company has won a battle against a mighty giant like PepsiCo. So that is a brand of PepsiCo Mountain Dew. So naturally, it really lightened up my eyes, and I thought, let's go and go deeper into that. So immediately, since it was concerning the IPR assets, that is trademark. So immediately, my first phone rang, and I just rang Shalala madam, and she is actually taking care of all the support we need as far as our customers, clients, or visitors are concerned about the trademark and IP kind of support, that is intellectual property rights. So immediately when I talked to Shalaga, her response was not like, "Arey, great, huh? She can't be okay. Let me check." Okay, that is the proper response which I got, and I was knowing something is going to be in that, which definitely is not like BSO. That is BSO is what? Bright shiny objects. So we should not follow these bright shiny objects in the media. So it may be truth, it may not be half truth, it is a full truth. I was not knowing about it. So I spoke to Ms. Shalaga, and let me introduce her. Ms. Shalaga is an IP expert, intellectual property expert, and I request you, Shalaga, welcome on the board. And I request you to throw straight away, we'll dive into the subject and throw the light on this subject. So I will give the access to share. So you can just go and share, and if you want to, I mean.
Yeah.
And you can just show the news and all that, whatever. And then we'll again come to conclusion. Right?
Yeah.
Over to you, Shalaka.
So this was the news in business today. As we all know, media makes this small news into a big giant. I mean, like David versus Goliath. So they had named it as David versus Goliath. David was McFirst and Goliath was
McFirst was the company. Huh?
Yeah, McFirst was the company. Saeed Ghaziuddin is the founder, and Goliath is of course PepsiCo. So
Okay.
this was fought for the brand name Mountain Dew.
Okay.
Both had applied for trademark, and we are going to see what are the uh, what are the facts now. And then we are not going to draw any kind of conclusion, but we will just have a smooth flow of how the things happen, and then what are the facts, and then now what is going to happen in future. So,
or at least where the matter lies currently.
Yeah, where the matter lies currently.
Yeah.
So Mountain Dew, whenever trademark, you have to apply for your trademark. We always suggest you should carry out trademark search and all. So probably this was not the practice, or we don't know. So this Mountain Dew was applied for by McFirst in 2003, and Pepsi. Now we will see how it proceeded and what all things happened. So McFirst launched its product in 2000, and they applied for this mark Mountain Dew in 2003. So when they applied, Now, whenever we apply for a trademark, there is a form called as TMA. So earlier, when they applied in 2003, there was not a fixed format. Nowadays, they have changed a lot. Trademark registry has improved a lot, and they want specific information about your trademark, like what all things you are going to protect under this mark. You have to include that. They have nice classification. They have detailed item list for nice classification for each class. Like for Mongenis, if we say example of Mongenis, I will take Mongenis is well known to all the viewers or listeners. So I will take that example. So if you see Mongenis, it has taken trademark for all the cakes like chocolate cake, vanilla cake, slice cake. So for everything, like if class 30, we take class 30, which is for cakes, they have shortlisted at least some 120 to 130 goods. So out of that, you have to select and you have to be specific nowadays for which products you have to protect your mark, or you have to take that mark as your registered trademark. So in 2003, that might not be the case. So when we see TM1 of MacFast, they only have this trade description that whatever is given for class 32. So packaged drinking water, mineral water, and all these things. So fruit juices, syrups, and everything. Now, when they applied, they might be having all these things in their mind. Later on, they modified it. Exactly after 1 month or so, they modified their TM1 to trade description to aerated water, including drinking soda, fruit juices, and syrups. Now, after that, in trademark prosecution, the steps are like this. Whenever you apply for trademark, there is a formality check. Like they will check whatever formal requirements you have complied or not, like the necessary forms you have filled or not, the necessary documents you have submitted or not. And if once they find that you have submitted this, you comply with all the formal requirements, your status will be displayed as formality check pass. So it means you have complied with formal requirements. If you have not, then they will display as formality check fail, and they'll send you the notice accordingly. And then you have to comply with those requirements. Okay. Now, in this case, now why this trade description is required or particularly important, let me tell you this, because they will check with the trademark list or nice classification list. And if you are not matching with the terms given in their nice classification, then they will send you formality check fail. So,
Okay.
so this has to be taken care of while applying for trademark. Now, whenever this formality check pass stage appears, after that your trademark application goes for examination. Now, similarly, this MacFast application also reached to examiner. Now you can see this. If this report you can see, then I'll just highlight it. You can see those marks which are similar to MacFast's mark have been cited by the examiner. So there are basically two types of objections in trademark. First is under section 9 and the second one is under section 11, which lists down the similar marks to the applied mark. So likewise, examiner has cited Mountain Dew by PepsiCo. If you can see here, PepsiCo in, so they have cited all the marks by PepsiCo. Okay. And there is one another Perrier Mountain Dew. So in this examination report, basically those marks which have the similar words or the phonetically similar words, these are all cited in the exam report, and the applicant has to defend or respond saying how his mark is different from these cited marks. Now, when these marks were cited in the examination report, nowadays they also state the status of these marks. Now, in this case, in the earlier examination report, there was not practice to list the status of that mark. So here we cannot see. But if we search with the help of this application number, we find that this Mountain Dew is a registered mark. So they have cited all the registered mark in the examination report. Unfortunately, on the trademark registry site, we could not find the response given by or response uploaded by MacFast to this examination report. So we couldn't know, or we are unable to find out how they have defended with these listed marks, like Mountain Dew of PepsiCo, how they have said that their Mountain Dew is different from this Mountain Dew. So this knowledge is not known to us, because the response to examination report, we couldn't find it. Okay. Now, once the examination report is filed, but it seems that since the mark was advertised in journal, it seems that they were successful in defending their mark in the examination report. Okay. So the next step, once you reply to the examination report, and then the mark is accepted and advertised in journal for other people to know that such kind of mark has been applied, and then you cannot make use of this mark, or it is other way around also for those people who want to oppose the mark. So for them, it has been displayed in the journal or published in the journal. Okay. Now, meanwhile, MacFast again applied for correction, and they now changed their description to trade description to packaged drinking water and mineral water being goods included in class 32. So if you can see, earlier it was all they included packaged drinking water and aerated water. Next, they only included aerated water, including drinking soda, fruit juices, syrups. And finally, they only maintain packaged drinking water and mineral water being goods included in class 32.
So you mean to say now there is no aerated water in this, right?
No. Okay. They have completely removed it.
And second point which I am observing here, for sale in the state of Andhra Pradesh only, that is saying.
Yeah, that is also something which is a element of ambiguity, because trademark is a territory, although it is a territorial right. If you apply in India, all over India you can use it. No, it's not like that.
State wise, it is not like that.
Yeah, since he is manufacturing in state of Andhra Pradesh, he will be able to use only in Andhra Pradesh. So this kind of description also I have seen for the first time.
Okay, but this description is taken off from the, IP side only, isn't it?
No, this kind of description is not there. Packaged drinking water and mineral water, that's it.
No, this particular TM 16.5, the trade amendment, these have been filed from the government side only, isn't it?
Yes. So
we can call it as a valid thing.
Yes. These are the documents which have been uploaded by Saeed Ghaziuddin. If you find out using his application number, you can see all these documents.
Okay.
And the dates on which these documents have been uploaded. Now, since the mark is published in the journal, so it was open for opposition. TM5, that is notice of opposition, was filed by PepsiCo. Okay. So by putting the following clauses.
Ms. Shalaga, this is what I'm saying is, now, can you take to the earlier slide? Yeah. So this particular thing, this TM16 file again. So this is maybe the third amendment which he might have done.
Yes,
right?
yes.
So this third amendment was done in which year approximately? It's 2003 or 2004?
No, it was in 2004.
2004.
So it was before opposition.
That is fine. So the next one, next slide, please. So this slide, this is on 2008. So it took 4 years for Pepsi to understand opposite.
Yeah, because it was not advertised in journal. Okay. So unless and it is not published.
So it was advertised in 2008.
Yeah, it was advertised in
4 years. It was not advertised.
No, because it was going on continuously. These changes, examination.
Okay, so it took 4 years nearly.
Yeah, earlier it used to take a long time for these trademark and patent prosecutions, but now they have been expediting the things. Now within 1 month, you can get the examination.
But there is one clear message, Shalaga madam. Yeah. There is one clear message that suppose somebody files it today, and you get suppose I file a trademark, some trademark, and I start dancing. I have got a trademark. So it may not be the cause of dance. After 3 years, somebody will come and may raise an objection, isn't it?
Definitely, definitely. No, not after 3 years, but this was since it was published late. That is why it is after 3 years. But normally it gets published within a time of 6 to 8 months.
Okay.
And once it is published, there is a time limit for the opponent to oppose it.
Okay.
Say maybe
Can you tell us what is the time limit like?
it is like currently 2 months.
Okay, so within 2 months,
2 months you have to apply.
So for let us assume that this is a case of Pepsi versus this, and suppose Pepsi would not have applied filed the opposition in 2 months, he could have used the trademark.
He could have used. So if we can see, this advertisement was on 1st Jan and it was applied on 30th April. But there the laws and rules keep on changing, keeps on amending, and that is why that time it might be 4 months or 5 months like that.
Yeah, maybe 6 months.
Or maybe 6 months, maybe 6 months. Yeah. So now it is limited to 2 months. So within 2 months you have to apply for the opposition.
Shalaka, there is one more. There is one more thing where I'm seeing the timeline here. Earlier there was no ISI BIS classification for bottled water. In 2003 onwards, 2003, 2004, this was two waters were distinguished. And came the whole bottled water came under BIS's umbrella. So they started identifying that ISI 14543 for the packaged drinking water, and this it may also be the cause of some effect over here. Might be.
Yes, might be.
Just a side note, nothing.
Yes. So now PepsiCo opposed, saying that there were three important. If we see the opposition notice, I found three important things or three important points to be noted. Firstly, opponent has said that they have been using this Mountain Dew, their mark Mountain Dew in conjunction.
Opponent is PepsiCo, isn't it?
Yes, Mountain Dew is PepsiCo. So
opponent is PepsiCo, right?
Opponent is PepsiCo, right? Opponent is PepsiCo. So PepsiCo has been using this mark Mountain Dew continuously in isolation or in conjunction. That is sole or in conjunction with or in combination with other marks like Diet Mountain Dew Code Red, and
what does it mean, Shalaga? For us,
Diet Mountain Dew is some Diet Coke or something, diet drink.
So does it mean that PepsiCo wants to say that they are already using this mark for quite long?
Yes, that's I'm coming next to it. Next sentence says that they have been using it since 1940, not in India.
Can you put a can you zoom it?
Yes.
Zoom it, yeah. No, not that. Yeah, that one.
See, the mark Mountain Dew was adopted by opponent through its predecessors in interest in 1940 and has been continuously used till date. So, not in India, but then all over the world, they have this registered mark since 1940. Okay.
That's what they say, yeah.
Now, in India, they came in 1985. They applied for registration of wordmark Mountain Dew as well as logo, and they got it registered, and continuously till date they have been renewing it. Like for trademark, the time period is 10 years. So term of a trademark, a registered trademark, is valid till 10 years. After 10 years, you have to renew it. If you don't renew it, you will lose it. So PepsiCo have been continuously renewing it since 1985. In 1985, they got both the wordmark and logo registered, and since then they have been renewing this mark from time to time. That is after every 10 years.
Shalaga, here I'm just stopping you for a while. I just wanted to make something clear. Under mark, the second column, Mountain Dew into bracket word per se. And under second row, it is logo. So it means for a common person that the words in combination like Mountain Dew cannot be used anybody but PepsiCo. Okay, and even the logo, the typical logo, cannot be used by anybody but PepsiCo.
Right.
Okay? And that is class 32 under which these goods are there, soft drink, beverages, and whatever they say. Now,
Right.
one thing is there, in 1985, packaged drinking water was not there at all. Okay. This packaged drinking water came into existence after 2003 when ISI identified this under 14543. Okay. But currently, why there is a concern that packaged drinking water also has class 32, I believe.
Yes.
That is what I want to make it clear. So whatever may be added in class 32, still they have a right on that. Am I right?
Yes, yes, yes.
Great input.
So see, if you see the soft drink beverages and syrups and concentrates and for the preparation thereof, and non-alcoholic beverages and syrups and concentrates. So although goods description they have given like this, and they have not claimed packaged drinking water. But since packaged drinking water comes in class 32 and Mountain Dew is a registered mark of PepsiCo in class 32, nobody else can apply for it, ideally.
And it is word mark. So actually these words cannot be claimed, isn't it?
So since they have Mountain Dew word also and logo also protected. So now the second clause was, I mean, this was the second thing which they cited. And the third one was this. The important thing I wanted to highlight is that, yes, what they said is opponent's mark Mountain Dew is a registered trademark in class 32 and applicant has applied for Mountain Dew in class 32, that too only for the state sale in the state of Andhra Pradesh. So what they said here that opponent's product under trademark Mountain Dew are readily available and popular in Andhra Pradesh since years. So although package, as you rightly said, packaged drinking water was not there, but Mountain Dew under the name Mountain Dew, PepsiCo's products were popular. So we know that. So since ages, I mean since 1985 maybe. So they are popular since 1985 in all over India. The territorial limitation of use of applied. So although we say ki we are only limited to Andhra Pradesh and PepsiCo is limited to all over India or outside Andhra Pradesh, that this territorial demarcation will not be applicable in this case.
That's what Mountain Dew says. I mean,
because once you apply for a trademark in India, so all over India you are free to use it, and nobody else should be infringing or encroaching your rights.
There is also, if you see the bottom sentence, apart from the use of Mountain Dew, there's also a logo which is similar to the Aquafina.
Similar to Aquafina. So
this is also a little ambiguous.
Yes. So that's why I have, if you can see these mountains and Aquafina mountains.
Actually, not much similarity, but
not much similarity. But then they had
it's
said,
okay. It's okay.
They have said in their opposition notice.
That's fine. That's fine.
They have said this one of the clause in opposition notice. So now, what I would like to say is, I'll stop sharing.
Okay. Yes.
Now, this PepsiCo will be going to High Court for this case. They will be again appealing to High Court for this particular Mountain Dew mark. But because they have their mark since 1985 and then this mark has not been registered. Now, MacFast mark, if you still see the status, they are saying it has been marked for amendment, which means this mark is not registered, and Mountain Dew by PepsiCo is still registered. If you see the status, it is registered. Yeah. So let us see what happens next. It's an interesting case, and it will be interesting to watch. I mean, what happens? Wait and watch what happens next.
Correct. Thanks for the input. So what I can say is that still only thing is it is let us not cheer up and dance. Like David versus Goliath, and
right.
Let's follow the media very slowly. So that even we understood in the COVID period also, we understood that very well.
Correct.
Many things, different news are coming. So we should always apply our wisdom in these kind of cases, and we should consult proper people, because I have seen Shalaga, many people go in emotion, and I will not name the case, but recently we have had a case
Yeah.
where that girl who
Hmm.
took out, who applied a year back. So
Hmm.
a huge giant has,
Yeah.
be
I
under the impression that I am a small player, not the biggies will not come to me. They will come to you. Okay, they will come to you and see you like anything, and that
right.
is how they really care about their brand. Why not? I mean, so
Yeah.
if you are establishing so much business, so it should not happen that you are going ahead with the brand and later after 3 4 years somebody comes and claims you. So it may be a troublesome time for you. So I
Yeah.
don't know what all these years how much MacFast is doing and all that. So I really do not know, but it can be a real difficult time. So
Yes. Yes.
why not? I mean, and why should we copy always the others? Isn't it?
No, I mean, like these big giants will come into picture when they'll say their financial loss, definitely, because they have been investing so much, and definitely that is a encroachment on their intellectual property. If you
Correct.
see these local bag manufacturers using Nike logo, but that is not much affecting Nike's business. So Nike is not investing in suing these local people. And there is no point in suing these local bag manufacturers. But
Hmm.
whenever if someone else is
It does not
installing,
affect much.
it doesn't affect much.
Yeah.
But someone is installing a mineral water plant and having a logo which is similar to a well-known mark or well-established mark, we can say. So definitely they are going to sue. I mean, they will oppose your mark. So you have to be vigilant enough to know who are the market players in your particular area, and you have to be what you can say, alert what logo and what mark or word mark, which are the words you are using for your mark, what are the color combinations. So something which is a challenge to your creativity, and you should use that, and definitely that is not going to get opposed, and you will get a good brand value and a loyal customer group.
Yes. So
Hmm.
first of all, I would really recommend you that you do some original creativity, and
Hmm.
even if you feel
Ah,
that you're original, you should be cross-checked whether you are original or not.
correct.
Go to people like Shalaga or your local players, wherever you are.
Right.
Do the IPR search properly. Get it done properly. Instead of doing it on, pay somebody and get it done because you're an entrepreneur. All jobs
Yes.
you should not do. You should
Correct.
get the jobs done from proper people. It's
Correct.
not simply mean that government has put up a set anybody can do and do it. It's not for any Tom, Dick and Harry. Delegate to the proper person. Get the search done properly. Let it be done enormously because it's the first step.
Hmm.
Establish a trademark and sue like Pepsi or other parties do. They care that much. Then only you can really become a brand, and it can become a real differentiator when you are establishing a packaging water brand. So
Correct.
currently, many people come to us, so saying that they have lesser budget. So with lesser budget also you can do because there are already many plants established from whom you can get it done and be professional, establish your brand, get the IPR properly. IPR does not mean only trademark. There are certain processes also you can
Yes.
get patent for
Get
that.
it.
And these processes are not necessarily be the technical processes or some scientific processes. It
Hmm.
can be as simple process as a
Yes.
distribution process for your bottles.
Correct.
So anything and everything can be protected. And for this protection, Government of India also given some kind of assistance.
Yes.
So for that, I would just like Shalaga you to say about that and what a typical startup should do about it. Typically, I will tell you, typically people come to us with lesser budget and we are advising them that instead of establishing a whole new plant again,
Hmm.
you can just have a brand and you can get it done from somebody. In that case, if they have a different approach, how can they go to the government and under startup what steps they can do? Can
Yeah,
you
if
give small?
if they register it as a startup, basically, for to register as a startup, you need to have a LLP or a private limited company.
Okay.
So, if your budget is low, then you should go for LLP.
Okay.
I would suggest, and then register under startup, get DIBP certificate, startup registration certificate, and then once you get it, you will get benefit in terms of monetary benefit in terms of these IPR filings. That is, you will not have to pay the fees of professionals
Like you.
like us.
Okay.
So trademark designs and patents are covered under this SIPP facilitation, and then you will have to pay only government fee for trademark registration, which is very less. I mean, 4,500 rupees for filing and 500 rupees for hearing. So total 5,000 rupees. And then this official fee is only mandatory. Professional fee is paid by trademark registry to the professionals who are assisting you in filing.
Fantastic.
So, mhm.
That's
So
great.
startup, you can register as a startup and avail the facilities given by central
Does your company help in this actually?
Yeah.
Okay. So anybody wants to be in
So
touch?
for patents and designs, me and my partner Pallavi are listed in SIPP facilitators list by patent office. You can find us on startupindia.gov. But for trademarks, our associate is there who is listed in the SIPP
It's okay.
facilitator for
If
trademarks.
somebody comes to you for
Yes,
the
yes,
IP thing,
we
they
can do
will
that.
get a single solution under the umbrella.
Yes, under one roof.
Your company's, I think, your DP name says that IP Adventure.
Yeah.
You can just go there, find out, or just drop a mail to us. We know the project information. They are the experts. They are the subject experts for the project information, and we shall be covering similar case studies as far as IP is concerned and concerning to the water.
So it's fun to learn the act and rules and regulations through these case studies.
So I would really appreciate. So in time of hardly 7 to 8 days, you have put up so much effort and you found out something very relevant for this, and this will put the light on the case. And I hope the viewers will definitely understand the importance of IP protecting their differentiator. Okay.
Right.
So we have training, as you know, we have trainings for packaged drinking water business, and there you come. That is idea to actualization. Now we have started taking the weekday sessions as well, weekend sessions. So friends, stay tuned to it and subscribe. You must have been, and don't forget to press the bell button so you not miss single notification. So thank you so much. I'm Soumitra and Shalada. Thank you so much.
Thank you so much for giving me this opportunity to come.
So we are not giving you once, you will be coming again.
Yeah. It's always nice to explain about these cases and enlighten or make aware, educate people about this, because if people are doing these mistakes, we really feel bad if somebody is doing these mistakes and they are not getting their mark registered or their IP registered. So
absolutely. Thank you so much.
Yeah, thanks. Okay.